Hello and welcome to the Entrant. The topic for today's discussion is one of the most relevant topics under Indian civil laws. The constituents of a tort holds great importance when it comes to questions asked in competitive exams. Let us start off by understanding a little about what a tort is. The word tort is derived from the Latin word tortum, which means twisted or crooked or wrong. When one deviates from this straight path into crooked ways, he has committed a tort. A tort is an act or omission that gives rise to injury or harm to another and amounts to a civil wrong for which courts impose liability. Usually, the injured party in a tort action is entitled to claim unliquidated damages, that is, compensation that has not been previously determined, specified, or agreed upon between the parties. The tort law has evolved from the maxim ubi jus ibi remedium, that is, for every wrong the law provides a remedy. In simple terms, tortious liability can be said to be the combination of a duty of care, the breach of the said duty, and damage caused due to the breach of duty. The vested legal right creates a legal duty. Legal rights are the rights that are conferred by law on a particular party or person. To constitute a tort, the following two conditions must be met. The defendant must have done some act or omission, and this act or omission should have resulted in legal harm, that is, infringement of the claimant's legal right, and the wrongdoing or commission must be of such a nature that a legal remedy can be found. Duty of care is owed to claimant by the defendant. Standard of care is required in a given case, and if it is not met by the defendant, it stands broken. The breach must result in a loss that is suffered by the plaintiff. There must be an omission or some act on part of the defendant. An act or omission shall be wrong if the person sought to be held liable was under a legal duty. The relevant act or omission should be recognized by law. It should not be a moral or social mistake. It may be intentionally or negligently committed. The legal rights of others should not be adversely affected. All infringement of private rights are therefore enforceable per se, which means that no evidence is required. However, violations of public rights are not unless substantial damage is done to the complainant in addition to the injury to the public. The act or omission should result in legal damage or injuria. Damage means the harm or loss suffered or presumed by someone else as a result of wrongful act or omission. In all cases of torts, the complainant is required to compulsorily prove that legal damage has occurred to him as a result of the form of perspective of damage presumption. The rights are divided into two categories, absolute and qualified. If an absolute right is infringed, the law definitively presumes damage even if the wrongdoer has not suffered any loss of money. Violation of absolute law is enforceable in itself, that is, without any evidence of damage. The presumed damage is called legal damage. There is no presumption of damage in the case of a qualified right, and the violation of such rights can only be applied on the basis of the proof of damage. The act or omission should have resulted in legal harm or injuria, that is, infringement of the claimant's legal right. Injuria sine damnum. Injuria means the infringement of a right conferred on the complainant by law or unauthorized interference with the right of the complainant, however trivial it may be. Damnum refers to substantial money, comfort, health, loss, or damage. Thus, injuria sine damnum means the infringement of the law without causing the plaintiff any harm, loss, or damage, whereas damnum sine injuria means the substantial damage, loss to money, comfort, health, or the like. And this damage is not accompanied by unauthorized interference with the lawful right of the plaintiff. The wrongdoing or omissions are of such a nature that a legal remedy can be found. Legal remedy is the third necessary remedy for a tort action. In tort, the wrongdoing must fall within the category of wrongs for which the remedy is a civil damages action. Civil injury is a tort, but not all civil injuries are torts. The essential remedy for torture is an action for damages, but other remedies may also be obtained. For example, in addition to damages in certain cases of wrongs or the complainant's own action without going to court, that is self-help. I hope this video was helpful in providing a simple and clear understanding of the constituents of a tort. For any further queries, please drop your questions in the comment box below. Please like and share the video and subscribe to our channel.